appeal are heard in the matter of awards of drinks limited in liquidation and the Commissioners for Her Majesty's Revenues in Custody.
Yes, Mr. McGee.
My lords, my lady, good morning.
Morning.
Yesterday, my lord asked me if we filed a PD52C note.
Yes.
We did, and can I hand that up, please?
Please. Well, while you're dealing with that's being handed up, another document, I'm not sure, we may have it in the supplemental bundle, I haven't looked, but the ruling that the Upper Tribunal gave, thank you very much, near the start of the hearing, you took us to that. Do we have a transcript of the ruling? I mean, was a transcript made of the ruling? I know they very briefly referred to it in their decision, but A, is there a transcript in the bundle of the ruling? B, if not, and there is a transcript, we'd like to see it sometime.
Well, my lord, if there is...
I don't think we're wanting you to go to the trouble of having it being transcribed now, but if there is a transcript available, we'd like to see it.
Well, the point at page 91 of the suggests that there was a
yes,
transcript.
indeed.
Made.
They gave a ruling. Whether it was transcribed, I don't know.
Can we find that and come back to you?
Yes, certainly.
I haven't seen it. If it was
okay. Well, I'm not asking. I don't think we're asking it for it to be transcribed. But if there is a transcript already in existence, then if we could be supplied with copies, we'd be grateful.
Indeed, and it's the reason I took you to paragraph 16 in the judgment, because that's the best we can do absent that transcript.
Yes, indeed. I understand.
I'll make inquiries, my lord. As to the note I've just handed up, I think it's very fair to say that no further scales will fall from your eyes.
No.
Not least because we filed this rather circumspectly at a time when we only had the grounds that Malone and Friends clients served before the UT. We didn't have the grounds or skeleton served in this court.
Why didn't you ask for them?
Well, we did, but we were getting the hurry up from the administrative staff to file one of these rejoinders.
So when was the so the appellant's notice is the 25th of August, and was their ground? So the grounds of appeal is a hold on. This is tab 5. Is that right? So that's in the court.
My lord, if it assists, it might short-circuit matters. The grounds were the same. So we submitted the grounds to the Upper Tribunal for permission to appeal, and one sees the decision behind tab 6. But the grounds
were the same?
Yes.
Okay. All right.
No,
what about the skeleton? Was that substantially the same?
I'm not sure that's the case, actually. I don't think we submitted a skeleton. We may have done a truncated skeleton. No, I think we just submitted the grounds to the Upper Tribunal. So there wasn't a skeleton. I'm sorry, my lord. Just the grounds.
In this court?
No, to the Upper Tribunal.
Now, what happened in this court?
Well, we submitted our grounds plus a skeleton argument.
Yes, okay. So, and the skeleton, so we've got the amended skeleton, of course.
Yes, what then happened was Lady Justice Rose gave permission on ground 1 only, not grounds 2 to 4. So she then directed that we resubmit our skeleton argument, stripping out the material.
Did you lodge the skeleton argument with the appellant's notice?
Yes, on grounds 1 to 4.
But you didn't, well, not you better, but those behind you didn't send it to HMRC.
Right. My understanding was HMRC would have been served at the same time, but I'll double check.
Well, they say they didn't get it.
Not before we filed the...
No, well, you should have got it when the appeal notice is
Can I take instructions on what the service procedure was?
Well, it's very unfortunate. Anyway, there we are.
My lord, Malone and Friends quite right that the grounds don't change.
The grounds don't change, so by that's right. Okay. So you had yes. Right. Thank you.
So, my lord, my lady, I left off yesterday dealing with the response to the request for further and better particulars, and we were in the supplemental bundle at page 126, and I had just dealt with the key responses that Malone and Friends says supports his contention, so that HMRC positively conceded that neither ADL nor its agents were actively involved in any diversion fraud. We went back through that, and my submission is that those responses cannot possibly bear the construction that my learned friend urges upon the court, and I would invite my lords, my ladies, so find. Indeed, all of the responses to that request 6, which starts at the bottom of page 123, were of a piece in making clear that all HMRC were saying was that no positive case was being pleaded against ADL or its agents. Can we turn back to page 125 just to look at those first 3 responses? Halfway down that page, response 1, the plea of inward diversion not made against, because HMRC does not need to make it against the appellant. It's particularised in paragraphs 7 to 8 of the amended statement of the case, i.e. no positive case. 2, the supplier of the goods is not a reference to the appellant, but a reference to the appellant's own suppliers. Now, this was a clarification that the particular plea on which request was made was not referring to ADL itself, but that no allegation was being specifically made against ADL was not in any way inconsistent with the overall approach that HMRC took, which, as my Lord Justice Richards put it yesterday, left it entirely open that ADL might well be the smugglers. There was no concession that ADL positively was not the smuggler in this response or in any other response. And just to finish this, response 3, HMRC does not allege, since it does not need to allege, that the supplier, as explained, is the appellant's agent as regards the inward diversion of the goods to the UK. Again, no positive concession that they actively weren't the smugglers. Now, when my learned friends, and I make no criticism of this, cite these responses, and in particular responses 1 and 3, the words, since it does not need to allege, were on each occasion left out. Now, in my submission, those words make even more clear that all we are saying is that there is no positive allegation of fraud. But on any view, taking these responses together, there is no concession as alleged by my learned friend. Now, turning back to my learned friend's skeleton in the core bundle.
Sorry, just before you go there, could you just remind me, I mean, does this document anywhere contain a reference to the sort of Brady principle? I mean, which rather underpins, I think, on your argument, the way in which the responses are rather carefully worded. Not to say more than they, so to speak, than they do, and don't carry any wider implications.
We don't expressly refer to Brady. There's a long preamble at paragraphs 1 to 7 in this document, where we say we're effectively pleading in accordance with what we said in the amended statement of the case.
Yeah.
And we're on Groundhog Day, day 5, in relation to Brady. We've had it twice in interlocutory matters. First before Judge Dean in the debarring application. Second in a case management conference before Judge Brooks before the FTT. It was argued in the FTT. It was argued in the UT, and we rely upon it again here. But the Commissioner's case, both in correspondence that my learned friend took you to yesterday, and the early drafts of the pleadings, and the case as put, were all entirely consistent that this was foursquare a Brady case. And just to...
And sorry, same question then, in relation to the amended statement of case. I mean, does that have any reference to the burden of proof and Brady in it?
The paragraphs we specifically relied upon in our skeleton, paragraph 13,
Yes.
in rebuttal of my learned friend's contentions, relate to the case we've made in relation to taxable supplies having been positively made in the UK. That paragraph starts paragraph 6 of the core bundle.
I may be wrong. I don't recollect seeing any specific reference, and of course one doesn't need to plead matters of law.
I didn't plead Brady expressly.
On the other hand,
just
sometimes it's helpful to do so, particularly in an area like this, which is so prone to cause misunderstandings.
Well, recounting that we had dealt with this both in correspondence at an interlocutory stage,
Yes.
and as set out in the documents my friend took you to yesterday, this, by the time we get to the ASOC, had been canvassed on a number of occasions. So there was no doubt by the time we got to the FTT that Brady was fully being relied upon.
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the Queen's Building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
I think that's what we'll do then.
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the Queen's Building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
I spoke too early, but I hope we don't need to hear it a third time.
My lord, there's no express reference to Brady.
Thank you.
It was very clear throughout, and my learned friend showed you the documents yesterday, that we had said, notwithstanding Mr. Jones's debarring application, that this was a Brady case, not a Three Rivers case. And just to finish that point, because my learned friend took you to matters arising before those two interlocutory spats, Mr. Jones's complaint against the commissioners was effectively that we couldn't use the F word at all without crossing a threshold that required, that triggered the professional obligations and the usual obligations set out in Three Rivers to plead fraud to the standard you would expect in such a case. And our response was, we're entitled to plead the background, which is that this all arises in the context of inward diversion fraud. The obligations to plead fraud fully.
Attention please. Attention please. This is the Incident Control Officer. The emergency condition has been resolved. The building is declared safe. All personnel may return to normal duties. All key emergency staff, please report to the main hall for debriefing. Attention please. Attention please. This is the Incident Control Officer. The emergency condition has been resolved. The building is declared safe. All personnel may return to normal duties. All key emergency staff, please report to the main hall for debriefing.
Fingers crossed.
Yes.
Yes, our position in response to the debarring application was no, we can plead the background circumstances and to say that this all arises in the context of an inward diversion fraud without expressly pleading as against you, ADL, or your agent, such as would trigger, which cross the threshold and trigger the pleading obligations that would follow. So we never felt we were in that situation. We always made that clear, and that arises from the correspondence that my learned friend took you to yesterday. And we were content, in fact, when it came to it before both Judge Dean and Judge Brooks, to make the amendments to absolutely clarify that we were not positively pleading a case of fraud against ADL, lest there be any doubt. So it wasn't, as my learned friend put it yesterday, the case that this started as a Kittle appeal, or any kind of appeal that triggered those fraud pleading obligations. We never accepted that at all. All we simply did was refine the pleading, lest there be any suggestion at the borderlines that we were running a positive case of fraud against.
I mean, when we saw just to say this, the original statement of case, it did look jolly like a fraud case. Yeah. But the point you're making is whether or not that's the case. it was clarified by your correspondence and by the amendments you made to the statement of case. Is that right?
Indeed. And to my Lord Justice Henderson's point, it was absolutely crystal clear that by the time we got to the FTT that we were taking the Brady burden points. As I say, we'd argued it twice out in the tribunal already.
Yes, sorry, I was interrupting you.
No, not at all. So turning back to my learned friend's skeleton, paragraph 38 in the core bundle, page 30. In that second sentence of paragraph 38, they say, rather, HMRC's case was the appellant supplier or the purported French customer.
Sorry, where?
I'm so
because
sorry.
we don't have the page numbers. Paragraph 30.
Paragraph
Yes.
38, and I'm in the
Internal
second
force.
sentence,
Yes.
where it said, rather, HMRC's case was that the appellant supplier, the purported French customer, diverted the alcoholic products to the UK. That was not our case. And then in the third sentence of that paragraph, they go on to say, HMRC then clarified, consistently with the acceptance that the goods had not been brought to the UK on the appellant's behalf, well, that's not what we said, that the plea that the sale of the goods was on behalf of the appellant was only meant to indicate that the money paid by the UK purchasers was deposited into the appellant's bank account. Now, with respect, that is an anemic reading of the pleading, and it amounts to saying that HMRC's case was merely that ADL's agents were agents for the purposes of depositing the money, not agents for the purposes of making taxable supplies in the UK on behalf of the appellant. Now, as we covered yesterday, and in the discussion you had, my lord, with my learned friend, it's clear time and again that we plead that the taxable supplies made in the UK were made by or on behalf of the appellant. So again, we don't accept my learned friend's reading of the response at paragraph 2 of the response to the request for further and better particulars at page 123 of the supplemental bundle. Which is where this line in paragraph 38 of the skeleton is taken from. And it really goes back to Lord Justice Henderson's point yesterday. We all know the ground rules. Nobody's saying that depositing money in a UK bank account triggers a UK taxable supply. And so the suggestion that we pleaded a response to this request for further and better particulars at page 123 to that effect, and that the agents were only agents for the purposes of depositing cash, is just not correct.
Well, I think it's like, I don't think it's those words "to that extent" are sort of slightly way. Those are the words that Mr. Beale puts in bold in paragraph 38. Not quite intent is.
What it's certainly not is a concession that there was no involvement in diversion by ADL or its agents.
I mean, you start that by saying HMRC's case is that the appellant's goods were sold.
Yes.
So.
And sorry, my point was also.
So I mean that it's just those words "to that extent." I think have given Mr. Beale a sort of.
Perhaps read with the previous sentence, my lord, we say this latches back on to the consistent pleading in the SOC that we are dealing with UK taxable supplies, not deposit monies. And that is clear reading the pleadings as a whole. Now, I won't go back through all the responses that my learned friend took you to. You saw them, you had a discussion with him yesterday, and I'm very happy to make the global submission that on no plausible construction of any of those responses, individually or collectively, was there a positive concession or acceptance by HMRC that ADL or its agents were not engaged in any fraudulent diversion of the goods to the UK. And again, I would ask the court to so find.
I mean, had that been the natural and obvious reading, one would expect that to have been the first plank in the defence before the FTT. And there would there would have been no need to concoct an elaborate story about sales being made to cash and carries on a in-bond basis, the type which was run at enormous expense and length and totally rejected.
Yes. Now, if I'm right about the proper construction that should be given to the responses to the request for further and better particulars, then, as I submitted yesterday, it does not matter that Mr. Howard made submissions for the UT, so the fact that a concession was made, albeit that, as we saw, he did so belatedly in reply, because there was no concession on which any such submission could bite. Now, at this point, I just want to cover off the source of, I say this respectfully, Lady Justice Rose's concern about what she describes as a potential contradiction in the UT's judgment. If we could please turn into the core bundle. The permission decision is at page 36. And if you're working from tabs, that's tab 4. Could I just start at the second hole punch, where Her Ladyship says, Ground 1 asserts that the UT misunderstood HMRC's case as evidenced by a statement by the UT at paragraph 50, that HMRC's pleaded case included French transactional documents were intended to facilitate the movement of goods to the UK to be sold on behalf of award. The UT records that HMRC did not allege fraud against awards, and that's paragraph 2. Paragraph 38, the Upper Tribunal records HMRC's concession that they were not alleging that award or agents of award had smuggled the goods into the UK. They also recorded the submission by counsel for award that it followed that HMRC must have conceded that award had lost possession and control of the goods outside the UK. So the premise for what's said below is that prior sentence, the UT records HMRC's concession. So could we then just turn into paragraph 38? We looked at it yesterday, but it's in the core bundle. Page 65. Where the tribunal says, while the above legal principles are uncontroversial, the parties disagree on how they apply to the facts of this case. Sorry, my lord, are you there?
Sorry, paragraph?
Paragraph 38.
38. Yes, sorry, thank you.
Yes. Second sentence. We deal first with the appellant's argument.
Yeah.
So it's recording submission. And there was two elements to the submission that were being recorded. First, that because HMRC conceded that no allegation was made that awards or agents of awards smuggled the goods into the UK, it necessarily followed that HMRC must have conceded that award had lost possession and control of the goods outside the UK. So just taking that in stages, the first bit of the submission recorded notes that no allegations were being made against award or agents. That was recording a submission that was rightly made to that effect. But again, turning back into Lady Justice Rose's permission decision, she records that as a concession, as opposed to a submission about a concession. But in any event, the concession was said to be that HMRC was making no allegation, i.e. no positive allegation of fraud. Of course we weren't, and we've established that. And of course this led me yesterday to say this was one of the three parts of the UT's judgment where they clearly recognised that HMRC were not making any such positive case. And then if we read the rest of paragraph 38, which my Lady Justice Rose also refers to, it said, further, in light of this concession, and again we're recording a submission here by counsel for award, it was not open to the FTT to make the finding it did. Such a finding could only be made if award retained possession and control of the goods when they were in the UK. So, not recording any positive concession that had been made by HMRC, just a submission about what followed, according to Awards Council, from the fact that we were not positively making an allegation of fraud against ADL or its agents. And then if we go back into Lady Justice Rose's permission decision, I want to drop down to the sentence beginning, there seems to be a potential contradiction, which is what I wanted to deal with. She says, there seems to me to be a potential contradiction between the statement in paragraph 41 and the fact that HMRC conceded that neither award nor agents of award had been involved in importing the goods into the UK. Now, with respect, there appears to be an elision in her ladyship's reasoning. As I say, she goes from recording what is said in paragraph 38, which is that 1, HMRC were making no positive case of fraud, and 2, recording ADL's submissions as to what they say, namely a further concession, or a concession that award had lost possession and control of the goods. And she moves from that to taking it as a fact that HMRC had in fact positively conceded neither award nor their agents had been involved in fraud. So, as you can see, having been through paragraph 38, that can't be taken from the Upper Tribunal's judgment, as I say, because it was merely recording submission, not as a finding of fact.
Yeah.
HMRC.
So, sorry, maybe the sentence you just read out, but so she says, she refers to the conclusion at the end of 41, that it was for award to show it had lost possession and control, and then skip the sentence. Then the next, there seems to me to be a potential contradiction between the statement in 41 and the fact that HMRC conceded that neither award nor agents of award had been involved in importing. That's where you say Lady Justice Rose is in error.
I do,
yes.
With respect. And I took you to 38 because she moves from recording a submission to taking it by the appellants to taking it as a fact that HMRC had conceded, and 38 is no basis for that view. Now, to finish this off, it's worth going back into paragraph 41 of the UT's decision. The contradiction that Lady Justice Rose perceived having fallen away, what we are left in my submission is the entirely correct reasoning in that paragraph 41, which, if you're working with page numbers, it's 66 of the core bundle. Now, this follows through from 38, but they say, we reject Mr. Howard's arguments. We agree with HMRC that award suggested analysis impermissibly reverses the burden. It rests on the assumption that HMRC had to plead fraud against award in order to come to a conclusion that the assessment, based on award's possession control, should be upheld. The point falls squarely within Brady, which confirms the burden remains on the appellant to show the assessment was incorrect, even if that conclusion may or indeed must involve fraud. And this is the crucial bit. Even accepting award's submission that it would not have supplied in the UK without possession and control, could not have supplied without possession and control, fraud did not need to be pleaded in order for a conclusion to be reached, which entailed award retaining possession and control. We agree with the commissioners. It is a non sequitur to say that because HMRC did not run a positive case on fraud, and there they are acknowledging in a fourth paragraph what's in the response to further and better particulars, they are taken in addition to concede the appellant lost the possession and control. The burden remained at all times on the appellant to discharge. It was for award to show it lost possession and control of goods. Now, that provided a complete answer to the submission made by ADL that HMRC, in not opting to pursue a positive case in fraud, logically entailed that it must be taken to have lost, because conceded that ADL had lost possession, ownership and control for Article 14 purposes. The response, in my respectful submission in 41, is quite right. The non sequitur in ADL's submission was that HMRC could only show that ADL retained ownership, possession and control by successfully pleading and proving fraud. But on an assessment, HMRC merely needs to exert itself with evidence and to exert itself sufficiently to bring forward a case to show that on the balance of probabilities, the assessment raised was correct. And that's what commissioners did by reference to the nearly 10 categories of evidence that was filed in the FTT subject of cross-examination and findings by the FTT and the UT to the effect that ADL did make a taxable supply, or did not show that it did make a taxable supply in France, such as to divest itself of ownership of the goods, and in finding that the case as put as a whole was just implausible. Now that conclusion is in fact encapsulated, I say respectfully again, entirely correctly by Lady Justice Rose in her permission decision on ground 3, where in the final sentence in relation to her reasoning on ground 3, she said the UT held that the evidence was overwhelmingly that there had been no genuine transactions in France, and therefore that a ward had not lost possession and control of the goods, citing paragraph 83. And again, as we discussed yesterday, as far as this appeal has gone forward on the basis that the FTDs are not to be treated as genuine documents, and where the FTDs were the only basis upon which ADL relied to say that, pursuant to those transactions, as they more neutrally ended up putting it in the Upper Tribunal, ADL had divested itself of the property and the goods, then insofar as they can no longer be relied upon, there is no basis upon which a case on divestment can now be pursued. And that, of course, leaves us with what my Lord Justice Richards put to my learned friend yesterday morning, namely, that there is conceptually only one route by which ADL can succeed in this appeal, namely by showing there was a positive concession by HMRC to the effect that ADL did divest itself in bond. And as I've sought to show you, there was no such concession. So I respectfully agree with the summary put to my learned friend that the choice is concession or bust. And absent a concession, we say then it's bust. So my lady, my lords, that is what we say on ground 1. Paragraph 50 contains no misunderstanding. The Upper Tribunal is well aware that HMRC has made clear it was pursuing no positive case of fraud against ADL or any agent. And we see that in paragraph 16, 41, 38 and 87. They're fully aware of the pleading submitted by HMRC. So the reference to facilitation at paragraph 50, we say, as a matter of construction, was the UT merely saying that the appellant did not divest itself of the goods in bond in France, such that the link between it, the goods, the sale of the goods in the UK was never broken. And in that it was quite right. So ground 1 falls away. One final point on paragraph 50. In its grounds of appeal and skeleton argument, the appellant contended that the alleged error in paragraph 50 affected the remainder of the decision. Now you'll see that the only way in which the alleged error was said to be operative for the purposes of the permission that was granted, or the permission that was sought, was in its ground 3. And if you look at paragraph 4.3 of my learned friend's skeleton, or page 19, you see it was effectively contended that the ground 3 error, which permission was sought, resulted from the alleged ground 1 misunderstanding.
I'm sorry, where do we find that?
Sorry, my lord, it's paragraph 4.3 of my learned friend's skeleton, full bundle, page 19.
Internal page 3 of the new skeleton.
Yes. So that's the express way for the purpose of the application for permission to appeal, where they said the ground 1 misunderstanding was operative in a material way. But of course ground 3 now falls away, PTA not having been granted. But even assuming for a moment there was an error in how the Upper Tribunal characterised HMRC's pleaded case in that paragraph 50, we say it had no material bearing on any other material aspect of the judgment that is the subject of the present appeal. Grounds 2 to 4 have gone, and therefore the alleged error can have no impact on the conclusion of the case for the purposes of this appeal, and in particular the central issue of whether the Upper Tribunal erred in concluding that the appellant failed to discharge the burden on it to show that there was no taxable supplies made in the UK. Now, an attempt is made at paragraphs 41 to 42 of My Learned Friend's skeleton to effectively say how the misunderstanding had further impact in the reasoning. But we say the contentions in paragraph 41 and 42 hold no water because they do not bear on the central issue. And in any event, we would say that there are no errors, as is now alleged in these paragraphs 41 and 42. Just taking them in turn. It said at 41.1, the UT erred in finding, paragraph 49, that the Commissioner's case was that the entirety of the arrangements were a sham. It ignores the limited basis on which sham had been alleged, as identified in paragraph 36.2 above. Now, we alleged sham in a way that was entirely consistent with our central case.
Sorry, I'm sorry. So we're in 41, are we?
Forgive me, my lord. 41, and the first error that is alleged.
Oh, it's clear that wrong.
41.1.
Yes.
Yes.
Yeah, okay.
So our case was that the sham was that, notwithstanding the summary of the alleged transactions that had been supplied by Mr. Gluck, became an exhibit to Mr. Judd's second statement when Mr. Gluck didn't turn up. There was no supply of goods in bond, both because there was no divestment, as was our case, and because there was no consideration for the purported supply in bond, as was also our case. And in any event, going back to the point Lady Justice Rose made, insofar as we only go forward on the basis that the FTDs are not genuine documents.
I'm just sorry.
Yes.
I'm having difficulty with this paragraph. 41. In view of the FBP response, it's clear the UT wrongly considered that HMRC had been advancing a different case from the one which was in fact advanced. Wrongly. So is this? So what's this refer? Is this going back to the concession?
It seems to be, but we struggled with that first sentence as well.
All right. Well, then we're going to struggle with the rest of the paragraph because this error.
We took it that this was.
But I mean, 40. What the Upper Tribunal is referring to, isn't it? In what Mr. Beale refers to in 41.1 and 41.2, is the evidence of what was going on in France, and your case that was all a sham.
Yes.
Yeah.
Because
but that's what the UT is referring to here. That what has been referred to in technical terms as the cock and bull story.
Yes.
And
there was no error.
I mean, that was your case. It was all a sham.
Yes.
Yeah.
But
that's what I can't see where there's any error in what the Upper Tribunal says there. I mean, I suppose I'm agreeing with you. I just don't quite understand the point in 41. But I think the the misunderstanding, which appears in 41, is that what the Upper Tribunal is referring to as the Commissioner's case related to all the story put forward as to what had gone on in France, the sale to the cash and carry people and so on. That's what your case was, that was a sham.
And the short point was, in circumstances where our ultimate submission was that you failed to discharge a burden to show that there was a supply of goods, which involved a divestment, or which involved the supply of consideration, was due to these 10 categories of evidence which showed that it was a cock and bull story.
Yes,
so even if there is a mischaracterization in 50, it would have had no material impact on the conclusion on that core issue at all.
But I mean, if we look at paragraph 49, they are clearly referring to France. They're referring to the case being advanced as to what the positive case being advanced by ADL as to what had gone on in France. That's all that 49 is concerned with.
And they don't come close to discharging the burden of showing that there positively was a supply of goods in France.
Correct.
So I will take that short, my lord.
Yeah, I think so.
And finally, we strongly object with respect to paragraph 45 of Malone Friend's skeleton, when it is said, as a result of mischaracterising the Commissioner's case, so this again appears to build out of the ground one misunderstanding allegation, the UT failed to identify the flaws in the FTT's reasoning. Now we see how this appeal is being used as something of a hook upon which to hang the FTT's decision out to dry, even though this appeal does not concern any error made by the FTT.
So this is paragraph
45.
45.
And we see that what follows in the rest of that paragraph 45 and 46 is an attempt effectively to challenge the underlying findings made by the FTT and the UT on the basis that there was sufficient evidence such that the FTT and the UT ought to have held that the burden of proof had been discharged. That's particularly clear in the first two sentences of paragraph 46, which says, taking the case at its highest, that case, HMRC's case, does not establish the supply of goods by ADL acting as a taxable person in the course of its business within the United Kingdom. Each of the FTT and UT should have so found. But that's an Edwards and Bairstow challenge, my lords, my ladies.
So don't. So I mean, 45 and 46 is surely simply again building on their case about the concession.
It is, but to the effect that, and here they're building up to the relief sought, i.e. remission to the FTT, because it is said both tribunals below should have found that the burden was discharged.
Well,
I mean, your basic point is that it's simply not open to the appellant in this court to challenge findings of fact made in the FTT, isn't that right? Because
that's the short point.
but I'm just struggling to see whether that is actually what they're doing. That's why. Are they? Which I mean, sorry, I have to read this more carefully again. But
well,
the specific way, and this is 45, in which the Commissioner's case was put, meant that it was necessarily being suggested that goods held by ADL in bond in France had been diverted to UK, but not at ADL's instigation or through delivery by ADL, by or sold by persons who were not acting as agents for ADL, and so on, but only because the monies had been remitted to ADL. Taking that case at its highest, it doesn't establish a supply of goods by ADL acting as a taxable person in the course of business within the UK. I mean, that's all just building, it all goes back to the concession. So I don't think it's really Edwards and Bairstow's.
well, either way, it doesn't work.
I mean,
if it's relying
they should have found, they're not saying, they should have found that that the HMRC's case does not establish the supply of goods by ADL in the UK. That is because of their concession.
well, if that's all it's
Well,
saying,
that's how I read it.
okay, well then I rely on
Yes.
my submission that there was no concession. But if there is another reading available and it is a more substantive challenge to the way in which the evidence was weighted, then you have my submission that's outside the scope of the ground.
Yes, that I see. You see, the commissioners had disavowed any suggestion that ADL had sold the goods in the UK through designated agents. It cannot, in law, have made a supply. I mean,
Well, that is from the
this is all the concession, isn't it?
It struck me as though it may potentially be going
All right.
beyond
Well,
the
you've covered
concession.
that off
And I've
anyway. You
covered
say that if it's simply a challenge to the findings of fact, then it's not open.
not open to them. So, my lords, that's all I then wanted to say on the residual points on the attack on paragraph 50 on the material impact it is said to have had on the rest of the reasoning in the decision. My lords, my lady, before turning to disposal, I wanted just to say something briefly in response to the marker twice laid down by my learned friend yesterday in relation to how they might seek to take this matter further. And specifically, I took my learned friend to be suggesting that Brady may violate the EU law principle of effectiveness. Now, my lords, my lady, could you turn back, please, into Mr. Beale's skeleton? And it's ground 4, covered at paragraph 4.4. So permission was sought in relation to the alleged procedural irregularities and unfairness before the UT and FTG, which infringe general principles of EU law, and that they constitute an infringement of the rights of the defence under EU law and or sanction a disproportionate imposition of that on ADA. Now, it seems to me that there must be some doubt, given how my learned friends cash out what they mean by infringement of general principles being a reference specifically to a violation of the rights of the defence, as to whether he could now say, as a matter of construction, that an attack on Brady and Brady's compliance with effectiveness came, in fact, within the scope of the ground 4 permission which was sought. And even if it does come within the ground 4 permission that was sought, it's obviously been refused. So the letter PTA can again go on the court collective note.
Can I just see the terms in which it was refused?
I think pretty shortly, she just said it doesn't add anything.
Doesn't add anything.
Yes.
I remember.
Well, I don't. Yeah. We don't have the skeleton that was before Lady Justice Rose, do we? But is there a point here? I mean, she would have actually, wouldn't she have had to refuse? Or would she have? No. You're saying, was it open to her to give permission? I mean, if that was intended as an attack on Brady, would it have been open to her to give permission, given that Brady is a decision of this court?
No. And
but that wouldn't of itself mean that the appellant couldn't seek permission to go to the Supreme Court.
given your point on precedent,
Yes.
my lord.
I mean, the point would have had to have been made very explicitly, wouldn't it? To say, we want to take this point to the Supreme Court. We acknowledge Brady is binding at the Court of Appeal level.
Yes.
We need permission in order to use, in order to try and get the Supreme Court interested in due course.
Well, my first and maybe my only point, in light of my lord's interjection, is that because this ground 4 was sought on the basis that specifically a complaint was made that there was an infringement of the rights of the defence, this is not an application that properly construed covers an attack on Brady and Brady's compliance with the principle of effectiveness. So on that basis, if Lady Justice Rose had turned around and said, well, it was just not there for her to draw out, but that's something that my learned friend might want to.
So what you're, let me get this right. I mean, a point that could be made about Brady, of course, Brady was decided quite a long time ago, and I mean, without turning it up, I don't know whether there was any argument about EU principles of effectiveness.
No, there wasn't.
So I mean, that actually, so going against myself for a moment, I mean, I'm not even sure whether that principle was in play at the time that Brady was decided, but that might open the door for the matter to be reconsidered even in this court.
Well, my lord,
I don't know. One would have to think about that. But anyway, your point was that they sought permission under ground 4 to raise the Brady point. So this is what
I say they don't.
They don't, but they should have done.
Yes, so it's out with the scope of the permission that they
Well,
sought.
either they did and it was refused, or they didn't and they should have done. That would perhaps be it.
I think probably more the latter than the former, but
All right, you go with the latter.
I'm happy to have that. But it's the words "in that they." It's the way they cash out the breach of the general principles. And so normally you get express reference to the principle that you're relying upon, whether it's transparency, effectiveness, or so on. But here, general principles in that they constitute, and they being the procedural irregularities and unfairness, they violate the rights of the defence. So if there was to be a specific attack on Brady...
Yeah, was this dealt with in the skeleton to the Upper Tribunal. I mean, what I'm basically saying is that one wouldn't just look at the short terms of the grounds to understand what is being driven at. You would, I think, look at the skeleton as well.
I don't recall that it was.
No, no.
And I think it's in the supplemental bundle. I don't want to mischaracterise the case that was taken.
No.
My Lord, if it assists, the way it was articulated below was as follows, that yes, Brady establishes a principle, but we're out with that principle because of the way that the Commissioner's case is being cast in the statement of case and in the further and better particulars. I think that was how it was put. Brady is to be distinguished, which is the line we've run here in the light of the factors I indicated yesterday.
Well, to that.
Oh, wait, but I think, Mr. McGurk is addressing the marker now.
Yes.
Which it sounded to me as if you would be seeking to say that Brady either was wrongly decided at the time or can no longer be treated as good law in this context.
Yes, I mean, my learned friend may be tilting a windmill. The point of putting the marker down was to avoid argument somewhere else in due course about whether or not I'd given the game away too much here by accepting Brady. I was simply saying, look, for present purposes, I haven't challenged Brady because it seemed a rather uphill struggle, especially given the composition of the court and the ingenious case, if I may say so, my lord. But nonetheless, I wish to reserve my position so that this type of point wasn't taken against me should we go further. Heaven forbid.
You get some understanding of what ground 4 involved before the Upper Tribunal, in the Upper Tribunal's decision refusing permission to appeal to the Court of Appeal.
Yes.
It's dealt with in paragraph 16 and following on page 54.
It says tab 6.
Yeah.
So paragraph, sorry.
The meat of it's in paragraph 17.
17.
I'm so sorry, 17 of what? It's my
Says-
fault entirely. I wasn't
So sorry, it's tab 6. It's the
Thank
decision
you.
of the Upper Tribunal
Yeah,
refusing permission. So the ground's very shortly described in paragraph 16, and then the Upper Tribunal deals with it in paragraph 17.
Yes.
It doesn't really seem to be talking about Brady, does it?
No, it doesn't.
No.
This also dovetails with the Groundhog Day point that I made. We had the argument 3 times before, we had it again in the Upper Tribunal, and the case didn't proceed in the Upper Tribunal on the basis that the principle in Brady expressly violated the principle of effectiveness in EU law. There we are. I'm happy to say, to leave it at, it's not covered in ground 4, it's not before this court.
Yeah.
And we'll see what my learned friend has to say in any further written document.
Yeah.
Turning finally and very briefly just to disposal. As I noted at the outset, the appellant invites this court either to remake the decisions itself and thereby quash the 2 assessments, or alternatively remit the matter to the FTT for a full retrial. Now, of course, if you are with the Commissioners, we simply invite the court to dismiss the appeal on the usual basis. If you're not, then we submit that neither form of relief sought is appropriate. As to the invitation to this court to remake the decision by quashing the assessments, our submission is that would be wholly inappropriate where this court has not heard live evidence, where it has not even had the benefit of the witness statements filed below, and where the appellant itself refused to agree to having even the most salient of the oral evidence in the first tier included in the supplemental bundle. And my learned friend very fairly said yesterday he may, in this regard, have hoisted himself by his own petard. Now, in those circumstances, the appellant cannot at the same time contend that this court has all the information that it needs to step into the shoes of the FTT and quash or remake in any other way, any other substantive way that is sought the decision. And of course, the Upper Tribunal had 5 of the salient witness statements, including...
Can I just stop you a moment? I may be wrong, but the way I see the way the appellants put their case is that by virtue of the concession which they submit, was made by HMRC, it was not open as a matter of law for the FTT to do other than set aside the assessments. Because, as I understand the way it's put, the goods had ceased to be in the possession and control of the appellant before they ever reached the United Kingdom. And it was put to me by Mr. Beale that it would be fanciful to suggest that, having lost possession and control in France, they reacquired it in England before on selling the goods. So, I mean, it wouldn't. I mean, it would be determinative, wouldn't it? That's really the way the case is put. Why would it be necessary to hear any evidence at all?
I see that. Dependent as it is on the concession.
Entirely,
Yes.
but I mean that's in a way. I mean because I mean Mr. Beale can't come to this court and say there ought to be more evidence or you should look again at the evidence. I think she accepted yesterday. I mean he has to say, given what he says was the concession, there was only one possible outcome as a matter of law, and that is that they won. So, I mean, my comments apply equally, in a sense, to what Mr. Beale was suggesting as a possible disposal, namely being remitted.
Well, on that base, I will hang my hat on the concession not having been made.
I understand.
I see the force in that, and I don't want to take a bad point. What we say would be the wrong way, respectfully, to deal with this would be to send all of this back for another trial, because again, that logically also follows the implications of submission made against us. And we've spent a lot of time and money establishing. This is all
No, I understand that. So.
My lord makes a fair point. I'm not going to take a bad point. I say there's no concession, and therefore we just invite the court to dismiss the appeal. Can I take a moment?
Of course.
Those are the Commissioner's submissions.
Yeah, well, thank you very much indeed, Mr. McGurk. Yes, Mr. Beale.
My lord, my lady, I have a handful of points in reply. Mr. McGurk yesterday said we were raising an argument for which the Upper Tribunal had not granted permission. With respect, that's not correct. The argument which was advanced and rejected by the Upper Tribunal was one which was advanced, as they noted, in our supplemental skeleton. That's made clear in paragraph 16 of the Upper Tribunal's decision. That's at Core Bundle 7, page 60. And I don't think we need to turn it up. I can simply read what it says. It says, the ward also sought in a supplementary skeleton argument it filed without permission on the 26th of February 2020 to raise a new ground for appeal, for which we refused permission on the first morning. So it's important to see in due course what that is. As I pointed out yesterday, the Upper Tribunal in fact heard submissions about the impact of the concession and the further and better particulars at various points. And I took you in particular, for example, to Core Bundle 8, page 119, where there's a long section dealing with exactly what the consequences of the Commissioner's, we say, concession was. And that, of course, is also dealt with, as my learned friend pointed out this morning, in paragraph 38 of the Upper Tribunal's judgment decision, where they identify the argument that is being raised and then deal with it in paragraph 41. And that's the very basis upon which Lady Justice Rose has examined the extent to which the answer that was given is determinative of whether or not a concession was made, and if so, what the consequences of that concession might be. So the argument that we've been deploying for the last day has been responded to within that time frame is an argument that was properly before the Upper Tribunal and indeed was dealt with. Moreover, this is the point that was in fact raised in our main skeleton argument before the Upper Tribunal, and therefore not the supplementary skeleton. Please could I invite you to look at that. That's in Supplemental Bundle, tab 17, page 210. Starts at 209, behind tab 17. We pick it up, please, at the next page, paragraph 4.
Just give us a second. So it's tab 17.
Tab 17, starting at page 210.
Hold on.
And please could I invite you to read paragraph 4 rather than go through it, because it sets out by extensive reference back to the further and better particulars what it is being said the commissioners must necessarily have accepted. When you get to subparagraph H, could I caveat what is otherwise an overly bold submission, which is that the respondents had accepted that it was trivially true in the relevant response. I think one can probably skip subparagraphs K and L on the basis that they relate to the financial transaction documents, and I don't have permission to go into that. But one sees there, it concludes at subparagraph M, that the missing link which the FTT did not address was considering in all these circumstances whether the appellant could have made UK taxable supplies of those goods. The importance of that missing link was recognised by Judge Richards in his permission decision at paragraph 5. I'll take a report to that in a moment. But the essential point that's being made is just because it hasn't been established that the particular transactions were as described by the appellant, doesn't mean if it's right that there was an intervening activity of a smuggling operation by persons unknown but who wasn't us, doesn't mean that one can say that possession and control hasn't gone. Unless one has effectively an allegation that we were the smuggler. And of course that was never the Commissioner's case. And that's the tension I identified yesterday. But my point at this stage is this was all set out in the main skeleton. And this was the argument set out in the main skeleton. And if one then looks, for example, at paragraph 11, page 216, refers to the fact that positive evidence has been presented. It was said that that was unchallenged evidence. I can't go there because of the grounds of permission that have been given. But it then says someone, not said to be the appellant nor an agent of the appellant, had sufficient possession or control of those goods after the appellant's transfer to smuggle the goods into the UK where they were sold. those goods must necessarily have been sold by or on behalf of whoever it was that had possession or control of the goods as they were being smuggled in. There was no allegation that they were ever reacquired by the appellant, then or at any other time after the goods became located in the UK, which would also be a logical necessity for it to make supplies in the UK of those goods. That encapsulates in a nutshell the submissions I belaboured yesterday, which took considerably longer than that paragraph to make. But the point is that was part of our main skeleton argument for the Upper Tribunal. And so the suggestion that this was a new argument for which permission was therefore not given on day one is simply wrong. And I took you yesterday to page 227 of this document, paragraph 38, where it said in terms that it would be contrary to the Commissioner's own case to say that we had remained in direct or indirect possession because of this intervention of the smuggling operation. Now, in contrast, if one looks at the supplemental skeleton argument, which is at page 255, that raises, admittedly for the first time, a reference to an Advocate General's opinion. I think it was either Advocate General Sharpson or Advocate General Bob, I can't remember off the top of my head, in the crack vet, which dealt with a situation in which vet supplies were being transferred between Poland and Hungary. Vet goods, I think, were being transferred between Poland and Hungary. I may not have the facts immediately to mind, but the issue was whether or not the haulage that took place was at the behest of the customer or at the behest of the supplier. And that was important because the supplies in Poland were being made to non-taxable customers. So, i.e., it was a B2C supply. And therefore, what was crucially important in that context was whether or not the goods were supplied by the supplier, at which point they would be treated in a certain way, or supplied at the request or the behest of the customer, at which point a different place of supply rule would be applied. And one sees that really at paragraphs 2 through to 5, where that analysis is going to inform a place of supply argument. And this was all directed at the dog that has not barked in this case, which is the retention of title clause. Probably that's not fair, because the dog that didn't bark was part of the conspiracy, of course. But this is simply not an argument that's been raised, which would, and therefore isn't an argument.
It's not before us, anyway.
No.
It featured below, as I
featured below as a respondent's notice point raised by my learned friend in, I think, as ground 3 of his respondent's notice before the Upper Tribunal. And the argument went as follows. Even assuming that you have somehow lost possession of the goods, you haven't received payment until the goods land in the UK, and therefore, pursuant to a retention of title clause, you had title to those goods throughout. And that is enough to mean that when you receive the consideration in the UK, it crystallises the supply, and there's therefore a supply in the UK. That was the way the argument went. The legislation I took your lordships and your ladyship to yesterday shows why that's a bad point, because you can have goods sold on deferred terms, consideration arrives later, doesn't stop there having been a removal of the goods cross-border. So it's simply a bad point. But it did detain the tribunals below for quite some time, and it was in response to that point. So this entire argument, as one sees from 7 through to 14, 14 in particular, one looks at that over the page, bottom of the page, paragraph 14. It says, even in the event where the FTT was not satisfied that the appellant has divested itself of possession or control in France by way of the FTDs, any supply must have begun there. That's never been in dispute. Then says, in VAT law, the physical location of the goods is not alone determinative of the place of supply. As such, in order for the FTT to have found the appellant has been a person who made a taxable supply in the UK, the FTT must have considered the place of supply rules under Section 7. So it's there assuming against us that we had, in fact, retained control.
But it's also assuming the FTTs were genuine.
Yes. Well,
they're not.
Well, it's assuming
because that's assuming they're genuine, then there's some divestment going on.
Well, it's assuming against us that they're not genuine. So it's assuming.
Is it?
Yes.
Well, then why would any divestment start in France?
Well, because the goods were always acknowledged to be in France.
Yeah, but it doesn't mean any divestment started in France.
So what is being assumed here is that the goods had been in France. They were then moved to the UK,
yes,
but we had control throughout. So this argument arises only on the basis that somehow we were responsible.
So which is the page this is on? Sorry. Well, it's in the supplemental bundle.
It's in the supplemental bundle, tab 24, starts at page 255. It should be at 257. I hope it's at the bottom of 257.
Oh, that's tab 19.
Tab 19.
Did I say 24? I'm sorry, I've been working from a different bundle.
Yeah.
So it's paragraph, the one
14.
you've just read out to us.
That's paragraph 14.
40. Oh, I see. Yes, so I misunderstood it when you were reading it out.
No, the whole point is...
Any supply, even if it wasn't by way of the FTDs, any supply must have begun there.
Assuming we've lost on everything, and the commissioners are right that we had these control of these goods throughout, nonetheless, it is said that the case law that is being referred to compels a conclusion that this taxable supply must have taken place in France.
Anyway, this is the... I mean, you weren't given permission to rely on this, were you?
But
I'm not...
that's why you haven't seen this argument before, because I haven't been running it. My point is, made very simply, we didn't get permission to run this argument, but this isn't the argument we've been running. I'm afraid it's a hair that's been set running by my long friend, but it's a hair that can be given its quietness, I hope. Now, in contrast, if one stays in this supplemental skeleton argument, you can then see from page 258 onwards quite how we had put the ongoing case relating to the extent of what we said were concessions as to what the Commissioner's case was. And indeed, the word concession is used repeatedly throughout this particular submission. And please could I try your patience by inviting you to at least cast a quick eye over page 258 through to 261 so you can see the shape of what was being said. Right, the first, I mean, perhaps I can take it with perhaps a degree more steering than I was suggesting. So we pick it up at the bottom of page 258. We say it's incompatible with the Commissioner's concession in the responses that the movement to the UK, which they allege was an inward diversion, was not done by the appellant or any person acting as our agent. There's then a reference to the draft statement of case, and the point is made here. Well, hold on, you were saying that we were party to this fraud in the draft statement of case. You then changed what you were doing, and that was revoked by the letter of the 9th of May that I took you to yesterday. So when my learned friend said it was never part of their case that there was fraud being alleged, I took you to the correspondence that said that.
Well, I think we made that point. But...
and then turning over to page 259, we see that the suggestion is made in subparagraph C that the Commissioners assert that it restricted its concession to confirm that they were not alleging that the appellant itself brought goods into the UK by inward diversion fraud, so that and no more. And it was said these submissions are wholly inconsistent, with the FBPs that I took you to yesterday. And in those FBPs, the Commissioners have clarified their assertion that the supply in the UK was made on behalf of the appellant was limited to the fact that the goods were only finally sold in the UK and the appellant received the consideration. That's to the extent that point that my Lord picked up on. We then see an express reference to the letter of the 16th of October 2017 that I took you to, where we had said there's no logical basis for your case on the basis of these concessions. And we then see at subparagraph F the Commissioner's allegation that their previous pleadings made it clear that they were considered the goods were moved to the UK on the appellant's behalf. It's strongly said, disingenuous if not dishonest. I would not associate myself with those words. What I would say is that where you are given further and better particulars as a litigant, and it says in terms, we are not saying you are the supplier, and the supplier who has smuggled these goods cross-border is necessarily someone else. As a litigant in my client's position, it's very difficult to see why you wouldn't take that at face value.
Well, I can understand that in general litigation, but this was all in the context of Brady, which had obviously been, or by this stage, well-ploughed territory.
Well, my Lord, Brady is a barrier behind which the revenue can sit if they aren't advancing a positive case on something. Yeah. But here they have positively asserted that there was a diversion fraud, and that was the means by which goods which were said to be in France have arrived in the United Kingdom. And that was the mischief, in a sense, of the further and better particulars. Why give them at all if my learned friend's intention was simply to sit behind the Brady barrier? And because they do have the very challenging, shall we say, implication that it's not being suggested by anyone that we were party to that smuggling operation.
Yeah, and they address, and it addresses Brady at paragraph 19 over the page.
Yes, and what we say is that this isn't a Brady case, precisely because the commissioners have exhaustively and unequivocally confirmed they made no allegation that we were the smugglers, or that the smugglers were acting on our behalf. If the commissioners decide to come out from behind what I call the Brady barrier and say, this is what we say, why can't a taxpayer in my client's position take that at face value? And it has this practical implication, if I may say so, which is, I wasn't at the time, but were I advising, hypothetically, a client in this situation again, is it really to be said that I now have to call for disclosure of all the supply chains that the commissioners have looked at in order to be able to confirm that these goods have in fact been smuggled? Because I need to therefore run a positive case that I was not party to a smuggling operation. And I can only do that if I have access to the supply chain evidence that the commissioners have looked at in order to satisfy themselves that there has been a cross-border supply. And it's part and parcel of their case that there has been a cross-border supply. And if I am told you're not party to that, then I may well think, well, I don't need to worry about that because it's not being said that I'm party to that. It would be an extraordinary request for a taxpayer faced with that pleading in the further and better particulars to come before the FTT and say, well, I can't take that at face value because it's Brady.
I mean, all you have to do is come before the FTT, tell the story what actually happened, and if you're believed, hey presto, the assessments are set aside.
Well, my lord, that requires us to put a positive case. The positive
Which you
case
have
is not
to.
accepted.
Which you have to.
Well,
I mean, that's what the
do.
legislation clearly does
we do.
require.
But of course, we also are entitled to take at face value what the issues are before the First Tier Tribunal.
Yes, but in the context of the background of tax law, including Brady, which is well understood by both sides and has already been ventilated in correspondence and two interlocutory skirmishes.
Well, my lord, if I may say so, what's the point of asking for further and better particulars at all?
Well,
Well,
the
indeed,
fact
there may
is,
not have been.
they were ordered. I mean, you asked rhetorically why the HMRC provided them. The answer is because they were told to, by an order of the tribunal.
They were
Is
told
that
to.
actually strictly correct?
Yes, they were directed by Judge
Well,
Brooke.
that is right, is it? That these particular, yes, I saw something in the papers which suggested there had been an order whereby you were given a certain length of time to ask for particulars.
Well, my understanding is that they were provided
Anyway.
before the deadline for them being.
Well, yes, indeed, yeah, okay.
It-
All right.
It matters not. There was a direction that particulars be given. Particulars were given.
Yes.
And we say that means that there's necessarily an adjustment of the Brady considerations because it amounts to a positive averment by the commissioners of what the position is. And that positive averment necessarily brings with it an allegation that these goods were removed from France to the UK as part of a smuggling operation.
And HMRC positively aver you were not involved in that.
They do. They
That's your case.
They've said time after number we're not involved in that, and every time.
Well, we come right back to the
Yes.
basic point.
Yeah. You'll see in this skeleton argument actually, there's what we alighted upon before dealing with some exchanges. At paragraph 20 was where my learned predecessor went through the points at which he or my learned friend had jumped up respectively to clarify exactly what the position was before the FTT. So these issues had arisen before the FTT, and we see, for example, at subparagraph C on page 260, Mr. Howard had clarified that the appellant's position need not be an attack on the respondent's particulars given their concession. There's then at subparagraph E, respondents noted their argument was that if the goods were returned by someone, it was a retention of title clause, which was sufficient for the appellant to have made the supply. So what's being said there is, well, to the extent that somebody else was therefore involved in the fraud, because we can rely upon the retention of title point, which, as I've indicated, is a bad point. We then see, paragraph 21, taken as it was plainly intended to be at the time, these concessions are only consistent with some person other than the appellant having possession or control of the goods at the time they were smuggled into the United Kingdom, and that must necessarily follow. If the accepted position is that there was a smuggling operation and that gave rise to the removal of these goods, then the consequence is either we were party to that smuggling operation or we weren't. And if we weren't, somebody else therefore has physically got hold of the goods and physically delivered them to the United Kingdom. And they say, Mr. Howard says, any alternative interpretation of the respondent's pleadings has left the appellant in a position that was plainly unclear as to the case it was facing. Moreover, it expressly stated it did not understand any direct or indirect allegation of fraud or dishonest behaviour was being alleged. Having now realised the impact of their concession, the respondents are seeking to row back from this and claim that such an interpretation is inconsistent with their concessions. This is solely a reflection of lack of substance in their pleading case. Well, vituperative observation I needn't endorse. But the point that's being made, the thrust of what's being made is we took these concessions as what they were, which was an acknowledgement that there was a smuggling operation and an acknowledgement that you weren't part. And if in fact it's being suggested, well, we may have said that, but in fact it was still for you to prove that we weren't part of the smuggling operation, then I'm afraid my client had been misled, inadvertently or otherwise, by the specific procedure that was adopted of seeking particulars in order to understand what the issues were, relying on that confinement of the issues and acting accordingly. Now, I should just also point out that lest it be said, well, it was still left open by the commissioners, that somehow it wasn't clear how the goods had transferred to the United Kingdom. Please could I invite you to look at page 170 in the supplemental bundle behind tab 19. This is part of Miller & Friends' reply submissions, so that the ones that went in about a month after the end of the hearing, 3 weeks after the end of the hearing. So that's page 170, tab 19, supplemental bundle. If we could pick it up, please, by the second hole punch.
So,
Page 170, tab 19.
Sorry, I'm getting lost. Sorry, I'm in the core bundle, am I? Sorry.
It's not, I'm very sorry, it's not tab 19.
Right.
It's tab 14, I beg your pardon.
Tab 14.
I'm working from the original bundle
Okay.
I served, and then bits came out of it.
Privatisation.
Tab 14, page 170. And by the second hole punch, it says the tribunal is invited to reject the suggestion the goods were returned to the UK via these alleged day trippers. The only other way for brands targeted to a home market to get back to the UK was via inward diversion fraud. And there is clear evidence for that in this appeal in the form of Mr. Llewellyn's evidence. The tribunal is invited to accept that is the only plausible way in which the goods were returned to the UK. That's a positive averment. These goods were in France. They've been brought back in through an inward diversion fraud.
Yeah.
And that isn't commissioners sitting behind the Brady barrier saying it's up to you to show us what happened.
Well, no, that's right. So they're saying they can't come in by inward diversion fraud. I think that had always been their case, hadn't it?
Yes.
And then you get to the Brady point.
Yes.
Yeah.
Well, you get to the Brady point to the extent that the Brady point is qualified by the necessary ambit of the case that has been averred by the commissioners. Because an averment does not equal, we're not going to get involved in what the detail is, you tell us what's happened. That's the Brady point is simply, we don't know.
But we know, or we say it was inward diversion fraud. Now it's up to you to tell us you weren't involved.
Well, they don't ever say that, Michael. What they say is, we accept you weren't involved.
No, they don't say that. They say they don't allege they were involved. That comes back to the point. We always come back to the proper meaning of, quote, of those responses to the FMBPs in the context of Brady, don't we? I mean, it just comes back time and time again to that point.
The positive averment in those FBPs that you've been to time after number, and I shan't weary you.
Yeah, we've got that. I think we've got both submissions.
The supplier that is responsible for the delivery of the goods is expressly identified not to be us.
Correct.
Yeah. And if you're right, HMRC shot themselves in the foot by making a concession which they didn't need to make, because you accepted, I think, twice yesterday. Had they simply said, we're just going to say nothing and leave you to prove your case, we wouldn't be here.
It would have been stewed in orange juice.
You indeed, yes. So, I mean, basically, your point is you have a technical defence, and it's one we should recognise and give effect to.
Yes, and I think it's fair to say I didn't exactly turn on the light in the jury box yesterday by raising the merits of the case. But I accept
You might have faced an even harder barrage than you did if you had.
Well, the fact that it's technical doesn't mean it's right or wrong.
No, absolutely, we accept
that,
that
yes.
entirely.
It simply means it's either right or wrong on the technicality of the VAT.
Yes.
But maybe after a day and a half's argument, and it's not a criticism, the case really does seem to boil down to one big point, which is the proper construction of the concession, in inverted commas, to be found in the FBPs.
Yes, well, that's often the way the best cases go, because
Yeah.
the points get distilled.
Yeah.
So we do say, therefore, that the refusal of permission here was on a different point. The arguments I've been wearying you with have been shadowed in the written submissions below, and that was not a new point at all. Now, the next point in reply is my learned friend said yesterday, repeated today, that HMRC should be credited with knowing enough about VAT law to know that the receipt of cash alone cannot give rise to a supply for VAT purposes. Could I just tweak his tail on that to this extent, that in fact that was the argument he ran in a case called Dale and HMRC in Bundle of Authorities, tab 21, and you'll see the rejection of that submission in the judgment of Judge Fawkes, as she then was, at paragraph 112. That's BA 21, paragraph 112. Because it's a somewhat cheap forensic point, I don't propose to turn it up, but I do think it's important to recognise that, as in this case, that case was being run initially on the basis that receipt of money by itself was enough. I took you to the VAT assessments that made it clear that was the basis of the assessment as initially put in place. Now, when dealing with the question of permission to appeal, my learned friend took you to a summary of that in the main Upper Tribunal decision. I would like you just very briefly, if you wouldn't mind, to cast an eye over the reasoning given by Judge Jonathan Richards, which is in Core Bundle, tab 9, page 182.
Sorry, go ahead. Core
Bundle 9, Core Bundle, tab 9,
Yep.
page 182. And in paragraph 5, after the first hole punch, that's page 182, just after the first hole punch, there's a sentence that begins, if, as the applicant alleges, it affected in-bond transactions that caused it to lose possession and control of the goods while they were located in France, then it's arguable that even though it had rejected as untrue the applicant's account of who its customers were and how they were paid, the FTT needed to go on to explain how the appellant came to make subsequent supplies of those goods in the United Kingdom. Just pausing there, that was the FTD point. The learned judge then says, moreover, if, as the applicant alleges, it lost possession and or control of the goods whilst they were outside the UK, it's arguable that to the extent that those goods were the subject of taxable supplies in the UK, those supplies must have been affected by persons other than the applicant, so that the applicant cannot have been liable for VAT on those supplies. Put another way, I'm satisfied that while the decision establishes that the applicant has given untrue evidence to the FTT, it is arguable that it does not support a conclusion that the applicant, as distinct from another person, is liable for VAT on supplies made in the UK. Now, that reasoning applies equally where the loss of possession or control is because of the intercession of somebody else's fraud, which necessarily connotes if the applicant, if the appellant in this case, isn't said to be party to that fraud, it must be somebody else's goods. So the learned judge had understood that that was the way that the case was being put. Now, at roughly 4:20 p.m. yesterday, 21st of April 2021, a learned friend said in his submissions, and I quote because I took a full note, "We are not saying ADL was smuggling the goods, and that has never been part of our case." That, with respect, reiterates the way we had understood the case that was being advanced against us. And that echoes what has been said time after number. What HMRC do say positively is that someone has smuggled the goods. And they then say that that smuggler was not an agent of ADL. And since we say ADL was neither the smuggler nor was the smuggler acting as our agent, the goods which we held in France cannot have been in our possession or control at the time that they were smuggled across the border. And we say that is sufficient to establish someone other than ADL removed the goods. As we've seen yesterday, removal of the goods cross-border creates a different taxable event, and that's why this assumes a significant point. The removal across the border therefore necessarily breaks the chain between the possession of the goods and the control of the goods by my client, and the fact that the self-same goods are then supplied by somebody else in the UK. As was indicated yesterday, it's fanciful to suggest that somehow we have reacquired the goods in England after the removal has taken place. Nonetheless, 3 minutes later, yesterday afternoon, my learned friend said the goods at all times were retained by the appellant, and that is what the FTT and UT found. So 3 minutes later, my learned friend is saying, but the goods at all time were retained by my client. And with the greatest respect, I just don't see how one can square that with the recognition that the goods have been smuggled by someone other than us. As it happens, there was no such finding by the First Tier Tribunal. The Upper Tribunal, at paragraph 91 of its decision, which you were taken to this morning, suggests it was implicit in the FTT's decision that the appellant never divested of possession in France. But you've seen that that was based on an analysis of the positive case put by the appellant. We divested of these because we sold them in bond. Answer rejected. It didn't deal with the legal submission that by virtue of the goods having been smuggled by somebody other than us, that also had necessarily given rise to a divestment of possession and control. So we do reiterate, but not extensively, the point we made yesterday that the Upper Tribunal simply did not take into account the nature and extent of the concessions which had narrowed the scope of the case between the parties. The FBPs, we say, with respect, have to mean something. They were sought specifically to narrow the issues. They were given. And with the greatest respect, it's not appropriate, having given those particulars, to then say, oh, well, Brady means that we can basically ignore those particulars because the burden is still on you to prove what happened.
I don't think that's what Mr. McGurk was submitting.
My lady, what he's submitting is the onus remains on you. Our positive case is that you sold these goods in the United Kingdom. He says that he hasn't accepted that someone else smuggled the goods. Well, if he hasn't accepted that, I don't understand why the further and better particulars were given in the terms that they are. Because if that wasn't his case, then it's very difficult to see why the particulars that were given wouldn't be thoroughly misleading. And that's the difficulty. As you all know, I've acted for the revenue on many occasions. Why bother to give particulars of something you don't need to give unless you are genuinely, that is your case? Sort of golden rule of government litigation, that you don't volunteer anything unless you really need to. But the commissioners obviously felt comfortable enough to volunteer these particulars or give them rather than resist them. And a wholesale response to the application for further and better particulars would have been, it's not for us to prove the case, it's for you to prove the case, and we rely on Brady. And it's sufficient, they would then say, we can identify receipt of money in UK bank accounts by a UK registered taxpayer. We raise an inference that those are taxable supplies because you're a business. You tell us why that's not true. That isn't what was done. And with the greatest respect, what we say is Brady can't conceivably have been intended to give rise to what would be tangible procedural unfairness. Brady can't be the answer once you've stepped out from behind the barrier, or, in a sense, stuck your neck out and said what you say the position is. There's two very minor points. The first one is to the extent that, and this was picked up by my Lord Justice Richards, that reverts back to the appellant's goods being sold. What, of course, it isn't saying is the appellant's goods were sold in the UK by you physically delivering them to a UK customer, and therefore, to the extent that necessarily qualifies the fact that what is being said is you've got the money for the sale of these goods, this sale took place in the UK, therefore it's your sale. And that was part of the way the case was put below. With respect, it's simply wrong, and it hasn't been pursued before this court. That's a tangible construction of the Principal VAT Directive, which would give rise to a supply of goods in the United Kingdom. It was then suggested, why haven't we launched a summary judgment application in effect? Why have we bothered to go through the, I think it was this point made by Lord Justice Henderson, why did we bother to deploy all that evidence on FDT so unsuccessfully and incur all that time? The answer was we had applied, as you saw, with Mr. Jones QC for effectively a summary determination. That had been rejected as matters stood. No doubt a view was taken that we had a perfectly decent explanation of what had happened, and that should be deployed as well. But it's not right with respect to say that this point was never taken. It was taken. I've accepted it was taken pretty lightly before the FTT. I gave you the references yesterday. But it was taken, we say, much more substantively, and we've seen the documents this morning, much more substantively before the Upper Tribunal. And, of course, it's the Upper Tribunal decision that we're appealing against. My lords, my lady, would you give me a moment? Those were the two additional points. I don't think I need to make the third one because I've already made it.
Yeah, I've just got a point I want to raise with you about your marker.
Yes.
Brady was an income tax case, not a VAT case. Is there any authority of this court that Brady applies in VAT cases?
There's an obiter dictum of Lord Justice Calm in the Greyhound case,
Aye.
2006.
But obviously, any, as it were, any conflict with EU principles would have been irrelevant in Brady, even assuming they were well established in 1987 or 88 or whatever it was.
I think it's fair to say they were in play, but not many people played with them.
But they wouldn't be relevant to income tax.
We hadn't yet reached the stage where the tentacles of EU law had reached into direct taxation in quite the way they said.
Well, they have reached, but even so, pretty restrictively. I'm not sure you could deploy EU principles as defences to. Anyway, the point is, I mean, it seems to me it would have been open to you to say that Brady doesn't apply in VAT cases by reference to EU principles in this court.
My lord, we took the view that it wasn't likely to be accepted.
Well, that's not a good reason for not raising it if you want to, and, as it were, keeping your powder dry for the Supreme Court, is it?
My lord, the position is that the Brady jurisprudence has been applied in VAT cases, and I took the view, for better or worse, that that persuasive.
But you could have raised it here. I mean, what Lord Justice Carnell said was obiter dictum. It wouldn't bind us. That's all the point. You could have run this point here.
My lord, Brady itself would have bound me.
Not in its application in a VAT case.
Well, unless there were grounds for distinguishing.
Well, you say there are because of EU principles.
Well, my lord, the point hasn't been articulated here.
Right.
Because I took the view that Brady and Ingenious, through a combination of that and Greyhound, would establish.
Ingenious was a first instance decision.
It was a first instance decision, and it related.
And Greyhound is obiter dictum, but I'm raising this because you will have heard me earlier sort of proceed on the assumption that Brady was binding on us, but it occurred to me as since that observation that it's not binding on us, so far as its application to VAT is concerned.
Well, my lord, whilst I've categorised it, I think correctly, as an obiter dictum by Lord Justice Calmwood. Lord Justice Calmwood was saying that the VAT principles governing best assessments are applied in parallel with the jurisdiction that's recognised under Brady.
Well, what I'm really referring to are your, as it were, EU arguments that you say, effective defence and so on. And it seems to me that those are not likely to have been in play in Brady. Query whether they even could have been in play in Brady, and it would have been open to raise them here in what is a VAT case.
Well, my lord, we've taken the view, as you know, that Brady can be distinguished because.
Yes, I understand that. I understand that.
If it's going to be suggested against me, that I could and should have challenged Brady before this court, then I will have to deal with that.
Well, you'll have to deal with that in due course, exactly. But I just wanted to.
My
just
purpose
to be
in
clear.
putting down the marker was to try and avoid an argument that I'd simply ducked the whole issue.
No, I understand. I understand. Well,
and
I understand that, but
if I could, in defence perhaps of our position, I had considered whether to run a challenge to Brady, and I took the view that it would be futile to do so.
fair enough. Fair enough.
And that's what an advocate has to do.
Yeah.
Does that mean I'm barred from ever raising the point again before the Supreme Court? We'll have
No.
to see if it comes to that.
No, it's a matter entirely for them.
Yes.
Also,
Well, you might ask
even win
us,
in
but
the
I mean, not having. Yes,
As I said, we'll have to see.
we'll have to see.
Yeah.
Any questions?
I think no.
Well, I have no further questions. I think, Mr. McGurk, you have a right of reply on Dale, if you wish to exercise it.
My tail duly tweaked.
You don't have to reply to it, but if you want, if you have the right to.
We obviously won in Dale, and you've seen the grounds on which we won in Dale. I put my case, I thought, on the basis that it was another piece of evidence in the scales, to the point Lady Justice Laing raised yesterday as to the inferences that might be drawn in relation to deposits being made in the UK. It was just another aspect of the argument in Dale. Dale was different to this case, though, because we had so many more transactional documents accompanied, quite importantly, by CMR and consignment documents. So we could marry up not just transactions with payments, but transactions, movements, and payments. And so more of the argument turned on transactional documents there than here, where ultimately the key transactional document, summary document rather than the underlying documents that Mr. Gluck produced and which Mr. Judd relied upon in the end. We obviously didn't appeal Dale. We didn't need to appeal Dale, and we're not in flow territory of needing to make an extraordinary application for permission to appeal against an order that we succeeded on. I think I'm experienced enough in VAT law to have known that that point on its own would not be sufficient in terms of the key provisions in VATA and the PVD. But there it is. That's Dale. If that's the way it was understood by Judge Falk, then there it is. But no one on the face of the amended statement of case, further better particulars response, could be in any doubt what our position was here. We positively alleged we were defending the assessments on the basis that there were taxable supplies in the UK by or on behalf of, as we repeated, not quite ad nauseum, but clearly enough that it was well understood.
Thank you very much. Good. Well, thank you both very much indeed, and those behind you. We'll reserve our judgments, which will circulate in the usual way, and hand down will be done remotely in due course. Thank you very much.
Thank you.